Lesson: California Consumer and Amendments, CPRA. The California Consumer Privacy Act, enacted in 2018, is a groundbreaking statute in the realm of data privacy, aimed at enhancing privacy rights and consumer protections for residents of California. Its subsequent amendment, the California Privacy Rights Act, which came into effect on January 1, 2023, builds upon the CCPA by introducing additional requirements and expanding consumer rights. Together, the CCPA and CPRA set a significant precedent for privacy regulations in the United States, offering valuable lessons for privacy professionals navigating state-level privacy laws and regulations. The CCPA was pioneering in its approach, requiring businesses to disclose personal data collection practices and allowing consumers to opt out of data sales. The law applies to for-profit entities that do business in California and meet specific criteria, such as having gross revenues exceeding $25 million, annually buying, receiving, selling, or sharing the personal information of 50,000 or more consumers, or deriving 50% or more of their annual revenues from selling consumers' personal information. By setting such thresholds, the CCPA targets businesses with significant consumer data activities, providing a framework for smaller companies to scale their compliance efforts accordingly. One actionable insight for privacy professionals is the importance of establishing robust data inventory and mapping practices. This foundational step is critical for compliance, as it enables businesses to understand the types of personal information they collect, the purposes of collection, and the third parties with whom data is shared. Effective data mapping involves cataloging data flows within the organization and identifying any potential risks or gaps in compliance. Tools such as OneTrust or TrustArc offer automated solutions that streamline data inventory processes, helping businesses maintain up-to-date records and facilitating prompt responses to consumer requests under the CCPA and CPRA frameworks. The CPRA introduced additional consumer rights, such as the right to correct inaccurate personal information and the right to limit the use of sensitive personal information. It also established the California Privacy Protection Agency, a dedicated body to enforce and interpret the law. The creation of this agency underscores the importance of continuous monitoring and compliance as regulatory oversight is expected to increase. Privacy professionals should therefore prioritize implementing comprehensive compliance programs that include regular audits, employee training, and incident response plans. These programs should be adaptive, incorporating feedback from regulatory updates and enforcement actions to ensure ongoing compliance and risk mitigation. A practical application of these requirements is the development of a privacy management framework that integrates compliance into business operations. The International Association of Privacy Professionals recommends a holistic approach that includes governance, risk management, compliance, and operations. This framework should be tailored to the organization's size, industry, and risk profile, and should involve cross-functional collaboration among legal, IT, HR, and marketing teams. By fostering a culture of privacy and accountability, organizations can better manage their data assets and build trust with consumers. The CPRA's emphasis on sensitive personal information, which includes data elements such as social security numbers, driver's license numbers, and biometric information, necessitates heightened security measures. Organizations should adopt encryption, anonymization, and access controls to protect sensitive information from unauthorized access and breaches. The National Institute of Standards and Technology Cybersecurity Framework provides a comprehensive set of guidelines for managing cybersecurity risks, which can be adapted to meet the specific requirements of the CPRA. By aligning security practices with this framework, organizations can enhance their resilience to cyber threats while ensuring compliance with privacy regulations. Case studies of CCPA enforcement actions provide valuable insights into the practical challenges and nuances of compliance. For example, in 2020, the California Attorney General's Office settled a case with a major retailer for failing to disclose required information and not adequately responding to consumer requests. This case highlights the importance of transparency and responsiveness in compliance efforts. Privacy professionals should ensure that privacy notices are clear, concise, and easily accessible, and that processes for handling consumer requests are efficient and well documented. Leveraging automated workflows and consumer portals can streamline request handling, reduce administrative burdens, and improve consumer satisfaction. Statistical data reflects the growing impact of the CCPA on business practices. A study conducted by Cisco revealed that organizations that invested in privacy compliance reported benefits such as reduced sales delays, improved operational efficiency, and enhanced customer loyalty. These findings underscore the value of privacy as a business enabler rather than a mere regulatory requirement. Privacy professionals should communicate these benefits to stakeholders, positioning privacy compliance as a strategic advantage that supports long-term business goals. The interplay between the CCPA and other state privacy laws is another area of focus for privacy professionals. With states like Virginia and Colorado enacting their own privacy statutes, organizations must navigate a complex regulatory landscape. Harmonizing compliance efforts across jurisdictions requires a nuanced understanding of each law's unique requirements and the ability to implement scalable solutions. Developing a centralized privacy governance structure can help organizations manage these complexities, ensuring consistency and efficiency in compliance efforts. The lessons learned from the CCPA and CPRA provide a roadmap for privacy professionals seeking to enhance their proficiency in state privacy laws and regulations. By prioritizing data inventory and mapping, adopting a privacy management framework, implementing robust security measures, and leveraging automated tools, organizations can effectively navigate the challenges of compliance while building trust with consumers. As privacy regulations continue to evolve, staying informed and adaptable will be key to maintaining compliance and safeguarding consumer privacy. Privacy professionals should also consider the broader implications of the CCPA and CPRA on global privacy practices. As more jurisdictions implement data privacy laws, there is a growing need for international harmonization and cooperation. Organizations operating in multiple regions should adopt a global privacy strategy that aligns with international standards, such as the General Data Protection Regulation, while addressing local requirements. This approach not only simplifies compliance efforts, but also enhances the organization's reputation and competitiveness in the global market. In conclusion, the CCPA and CPRA represent significant milestones in the evolution of privacy law, offering valuable insights and practical tools for privacy professionals. By embracing these lessons and adopting a proactive approach to compliance, organizations can navigate the complexities of state privacy regulations, protect consumer data, and achieve long-term success in an increasingly privacy-conscious world.